Thanks so much for joining us today. I'm Belinda McCauley, Executive Director of the Beverly Hills Bar Association. When I read about some of the ethics rules changes the new administration was making, I thought this could make a great CLE program, and I'm delighted that two fantastic experts were willing to present on the topic. But before we begin, a couple of housekeeping announcements. First, you will receive your CLE certificate shortly after the program. Please take a moment to complete the survey that we include with the certificate. It helps us develop future programming. And if you're a BHBA member, all of your certificates are available in our BHBA members only community online. If you haven't logged in a while, do that. We've got a bunch of new features that you should check out while you're there. There's a link in the chat to that. Second, we're putting a link to the CLE materials in the chat now, and you received a link to them shortly before the program as well, but always feel free to reach out if you're having trouble locating those. And now I'll briefly introduce our two presenters. They both have really extensive backgrounds, but I wanted to give them as much time as possible to talk with you today. So I'm going to give just very short summaries that I hope still do them justice, and drop the link to their bios into the chat so that you can learn more. First, Amber Maltbie is a partner in Nossaman's LA office and is a nationally respected campaign finance and election law attorney, which includes advising on campaign rules, government ethics, lobbying compliance, and all aspects of nonprofit entity formation. Amber's also very active in 501c3 groups in our local LA community and statewide here in California, and she teaches election law at McGeorge School of Law in Sacramento. Michael Stroud is a partner in Nossaman's DC office and has more than 15 years of legal and legislative policy expertise in a wide variety of issue areas. He previously served as Deputy Chief Counsel on the U.S. House of Representatives Committee on Homeland Security and held several roles at DHS, including Deputy Assistant Secretary for Legislative Affairs and Acting Assistant Secretary for the Private Sector under President Obama. And a point of personal privilege, Michael Stroud is one of my favorite people in the world. We met our first week at GW Law many years ago, more than probably either of us would like to admit, but we've been friends ever since. I actually realized in preparing for today that our friendship is now older than we were when we met. And I would like to think we were babies, but we were, in fact, in law school. So he was the first person I thought of when I was reading about these changes, and because he has such knowledge in this area. And I'm so grateful that he reached out to his law partner, Amber, to put together this great presentation for you today. So with that, I'm going to turn this over to our fantastic speakers. They're more than happy to take your questions throughout the presentation. So just drop those into the Q&A feature as you have them, and they're happy to answer. Thanks so much. So Amber and Michael.
Well, thank you, Belinda. I want to say thank you again for having us, and thank you for everybody at the Beverly Hills Bar Association. And I want to say too, you're one of my favorite people. You've always been. Obviously, we've been friends for a very, very long time. So I was very flattered to get your call and email to talk about this topic, and I'm looking forward to the discussion today. And from Amber and I, our preferences for people to feel free to ask questions as we go, and please use the Q&A or the chat. Sometimes I know people place them in both, but we'll be monitoring those, and we'll ask too if Alex can keep an eye on, or you can keep an eye on there too. And if there's something that we missed, we really appreciate it, because we want to answer your questions and want to have as much of a dialogue as we can today in this virtual format. So we want to thank you again for being here today. We are supposed to talk a little bit about ethics in Washington. And what we're talking about today also is sort of how ethics is likely to change in the federal government. And then also, we want to talk a little bit about the changes in government and ethics and how those will impact attorneys. And then also a little bit about sort of what we see on the horizon, and then also what is going to be happening in the ethics world, particularly at the state government level, and also in campaign finance issues at the federal and state level. So just to sort of set the background here, over the course of the last 3 presidential administrations, we've seen a fairly dramatic shift in the way that ethics has played a role in the public service and public sector. And by that, we mean, we left the Bush administration right around 2000 and the 2004 cycle there. And then in 2008, when Obama came into office, there was a big push to eliminate lobbyists from public service roles, and really try to place some restrictions on this sort of revolving door of government and how public officials were using or serving and then going into the private sector and sort of having this enrichment of them, of this gaining benefit off of this public service. So we've seen a pretty dramatic shift in that way. So I think part of what we're going to talk about a little bit today is just the difference in those 3 administrations. So from the Obama administration to the Trump administration to the Biden administration, and sort of how that's changing day-to-day operations, both at the federal level, but also just for anybody that's interacting with the federal government right now. So let's just start, sort of a little initial overview of the analysis of the 3 different types of 3 different pledges that we sort of saw. Obama came into office and we had this ethics pledge for lobbying ban, no lobbyists, and we also saw sort of you will not be allowed to lobby your organization that you served in. That was what happened when I came in and was appointed. We signed this ethics pledge and we agreed that we wouldn't lobby that entity for the duration of the Obama administration. Now, the thought there was that it would create a whole it would really kind of create a situation where people would think twice probably before going in the government, and it would also create more of a tenure and a real commitment to the entity, since people knew they wouldn't be leaving and then turning around and lobbying the entity. I don't know if it actually worked, but that was sort of the starting point. And then we had the Trump administration come in, where it was very clear that no one could lobby the administration during the length of the administration. And in fact, it was just an all-out ban on lobbying. We started to see that may not have actually been as effective as we thought, because people would then leave the administration and then they would say, well, I'm not really lobbying, I'm providing counsel and advice to people that are lobbying. So, but that's not me, somebody else. So we saw that happen. And then when Biden came in, we saw this sort of, this aggregation of the 2 different types of the bans, where you now have one where it's just absolutely, it's even more restrictive than the previous 2, because now you cannot help someone lobby and make a contact that they could not help make themselves. So you actually see like a ratcheting up, if you will, of the ethics requirements on those that are going in to serve as public officials. And I think Amber is going to talk more about some of this as well, especially with respect to gifts and restrictions on public officials. But we kind of wanted to talk a little bit about this. And if you want to see a detailed assessment, we provided an article that we wrote that was in the Law 360 that discusses the 3 different regimes, and it also goes ahead and kind of gets into some of the specifics if you'd like to look at those. But one of the things that we were talking about in this particular conversation is the fact that this playing field has shifted in a way that has made it is almost very steep for filling the roles of government. And this is one of the challenges that we're seeing today, is that essentially what's happening is the Biden administration has created such a high standard for service, that it will not have people that have been registered lobbyists for preceding, I think, 2 years. And so the reason that that's creating a difficult standard for them is that anybody that was a lobbyist that lobbied on a certain issue is not eligible to come in right away without receiving a waiver from White House counsel. And so that is creating a backlog in some ways of who can get appointments. And so what we've seen is it's been very sporadic with who can be filled and who can fill certain roles. Ideally, what we're seeing right now is a lot of legislative staff coming directly from Capitol Hill and coming into agencies. Why? Because if they've been on the Hill for at least 2 years, they could not have lobbied, so they don't have this problem. So anyway, we wanted to kind of talk a little bit about those two, about that particular issue and how it's contributing to sort of the slow filling, if you will, of government agency and government jobs. But let's talk a little bit about too what's likely to happen or could happen legislatively. I know that is kind of a big concern for people because one of the House priorities was HR 1, and that's having worked on a HR 1 myself. That is usually the speaker's priority. And in this particular Congress, the speaker designated the For the People Act of 2021 as HR 1, which means that is the speaker's priority for this Congress. And in that bill, it's primarily geared towards voting, campaign finance, and a lot of ethical reform. So I think let's start kind of going through that a little bit and just kind of talk about what we see coming up. And again, if anybody has any questions, feel free to put those in the chat or the Q&A, and we'll do it. Amber, please, if I miss something, please let me know, and I'll do the same for you.
Actually, we got a question already,
okay.
And this question, funny enough, is exactly what I was wondering about too, Michael. The question is regarding the waiver. So it sounds like the administration can grant a waiver to somebody who otherwise would be precluded from joining the administration because they'd been a lobbyist. So, my question and the audience members' question, my question is, who actually makes the waiver? Who gets to make that decision? Is there a standard for that? And, is it the administration just waiving whoever they choose? But is the administration looking at the optics of, granting waivers? Does that kind of undermine the whole purpose of this?
Right. That's a great question. It's White House counsel's office, and it's only, I believe it's only the White House counsel office, and there are specific requirements for those waivers. And typically it's in the national security interest or in the national economic interest. And it's designed to be a fairly narrow waiver. And that's a really great point to bring, is because it's very different than we found in the Obama administration, right? In that situation and in the Trump administration, there was really no, you did not really have a prohibition on having had been a lobbyist before. It was just that you essentially will not be going to lobby in this administration afterwards, right? So and then I guess in the Obama administration there was still some desire not to have lobbyists, but this one, in this case, we also noticed that the waiver process itself is very tight. It's very narrow. So and that's who would be granting the waiver. And yes, a lot of waivers would undermine the policy. So that's kind of the reason why the waivers are not being granted, except for sort of very, very limited exceptions right now. I do think, excuse me, I do think you will see tranches of people that would be requiring a waiver to be moved along as the administration moves forward to try to fill some of its positions. So I think you may see that happen. But that's a really good question. Yes. So wanting to pick up on where we were with HR 1, there's a lot in this bill. This bill's huge. And this bill in many ways is both aspirational and a political statement, as it is also a bill that is designed to revamp and revise some perceived gaps in our ethical and disclosure process. And it's also designed to create, really, in some ways, to some, reestablish some entities, reauthorize them. For example, the Office of Government Ethics, reauthorizing that office is also a statement based on the last administration and how there was some concern that the Office of Government Ethics was in fact not really being able to perform its function. So there's some reauthorization of that office in there. And this bill also looks at some of the very different nuances, for example, on congressional redistricting. Whatever your take is on that, this bill attempts to create an independent commission on that. I think the other thing that really happens in this bill that I think you're going to see potentially people kind of associating with and deciding is a good policy is the issues impacting foreign nationals. And this is, for a long time, we've had rules prohibiting foreign nationals from making contributions to candidates. But because of certain Supreme Court cases and certain changes in the law, we've seen a sophisticated level of foreign investment through U.S. entities and creating a pathway for some foreign influence, if you will, into campaign finance. And there's a significant portion of this bill that really attempts to try to narrow those rules for foreign nationals, including creating a certain structure for reporting foreign national contact to the FBI, also for certain political action committees and any corporations that maintain them, also having the requirement to deal with foreign contact that's reportable. We also see that there's an increased scrutiny on the digital platforms and noting foreign purchases for ads. This was really a direct result of the Facebook and the Russian interference investigations that we saw unfold over the last 4 years. So those are attempting to be addressed in there. We also see that there's a new public finance system for congressional candidates, which is again, whatever your take is on that I would enjoy any questions about that, or Amber, if you have any thoughts on that one. But it's a series of large donor, small donor, big donor, and that's it's going to be, it would be unique if it was implemented. And then I think one of the things we want to talk about too is that the fact that the Federal Election Commission, this bill would really attempt to sort of shore up and eliminate these huge gaps of functionality at the Federal Election Commission, or FEC. The FEC, this bill would change the number of commissioners at the FEC and take that up to 5. What that means effectively is that it would allow the FEC to keep its quorum for a longer period of time so that it could continue to address ongoing complaints and issues. So that's an issue that we think is there's probably some political appetite for folks to see that change. So that one may be worth watching. Also on the side of the on foreign nationals is, as we saw from Paul, the Manafort case, we saw it's called the Foreign Agent Registration Act, or FARA. And so we've seen an increase. This bill attempts to increase the level of specifications on FARA filings. And even though FARA has been a very public process for the most part in some ways, and a regulated process through the Department of Justice, a lot of people after the Manafort investigation thought there should be more attention paid to FARA. This piece of legislation tries to do that. It creates a separate unit for FARA inside the Department of Justice, gives the Attorney General 6 months to establish that unit. And then also it provides for additional prosecutorial authority. So this is something that would lead to more enforcement. And so understanding where and how, if you are working with a company that is a U.S. subsidiary of a foreign entity, understanding where you are and are not with respect to the FARA rules would be very important. And then the other thing we saw too in this bill that's of particular interest, for at least for some of us in the room, is that it lowers the lobbying threshold. There's been a huge industry of former elected officials who will leave office, in some cases gracefully, some cases not gracefully, and they will end up in a very nice consulting job where they are not lobbying, but they are counseling clients on how to lobby the government. And this bill would actually lower that threshold and change it where those people that are providing counseling that would support lobbying would in fact qualify as lobbyists. And that would be a very interesting thing to see happen. Sorry, Amber.
No. So we received another audience question to this exact point, and the question is, how expansive is the definition of lobbying? For example, if I've already started contacting Congress as a private citizen to support a bill, can I continue to do so if I accept a position with the administration? And I guess the question would be, what would the rules now be, and how would that change, if at all, under HR 1?
Sure. Well, you are allowed constitutionally to petition your government, and so as an individual, you're allowed to continue to ask the government to make certain policy changes. Really, the definition of lobbying, it really stems to around the fact of whether or not you're being paid to make the contacts, and that pay could either be direct hire for engagement on that particular issue. It could also be working in your role at your job, where maybe your part of your job scope is to create communications or to have communications with covered officials. And there's a certain triggering threshold in the statute right now that looks at how much of your time is spent or how many contacts you're making roughly. And that's sort of the benchmark for how we would determine that. But as an individual citizen, you can continue doing that. And you would not necessarily qualify as a lobbyist, provided that you're, again, not meeting those other thresholds. So with this change in the LDA that's proposed in this piece of legislation, we would see a lot of former officials particularly former officials that may want to go back and seek office. They may not be so quick to jump into these quote unquote consulting roles. So what this really attempts to do, and the Biden ethics pledge, is really trying to eliminate this practice of what we call shadow lobbying. And in particular, the Biden ethics pledge requires the government employees that are signing it that they themselves will not undertake communication to other people that is somehow prohibited. So what happens here is you might call your friend at agency A, and you might ask your friend at agency A, hey, I really need to get you to contact this person over agency B, and then have a conversation with me. Tell them I'm calling. The ethics pledge says, well, wait, I won't contact agency B because that's not a communication that I would be permitted to make under the Biden ethics pledge. And so what that's attempting to do is eliminate this concept of what we call shadow lobbying. So, and the bill tries to do another form of this, and it's basically another way to try to codify some of these things. The bill also codifies, for example, the Obama ethics pledge. So if you think about going back to that earlier part of the conversation, it's a gradation of steps. It's a lower, slightly higher, and a higher step. It attempts to at least set a floor at the Obama pledge and codify that. The other thing I think this bill does that could be interesting is really a theme that I've put together, kind of, it's called connecting the dots. For a long time, we've seen, and we've advised clients on this before, that, if they are potentially running into the FARA area, they may be able to avoid or comply with their initial requirements by filing under the Lobbying Disclosure Act. And so we routinely in DC will see firms that will go ahead, they're not quite sure where they should file, so they'll file a Lobbying Disclosure Act filing. And under the LDA, it sort of satisfies the requirements of under FARA until you reach a different threshold. What this bill would do is it actually would link the LDA disclosures and the FARA disclosures. And so the registrations would be in one place, which would be very unique and very different because you have to know where to look for the FARA registrations. The bill would also then link up the LDA registrations with the Federal Election Commission reports. So you could see who is actually paying for, or who's contributing to candidates, or who's at doing political spending around the Lobbying Disclosure Act filings. So that would be a very interesting thing of a sort of information sharing in government. And then, as I mentioned before, too, it all, obviously authorizes a couple of these offices. There's a lot in this bill. There's a lot I didn't touch on. There's a lot that made it in through amendment as well, but I just thought it would be kind of worthwhile talking about some of these requirements. Overall, I don't think the whole bill makes it. I think what we're talking about, though, are probably some very discrete parts of the bill that have some bipartisan interest. They probably will get a second look. This bill has left the House, so it's in the Senate right now. And the question is, what is a 50-50 Senate going to do? And then, of course, if it's something different, they'll have to send the vehicle back over to the House before it would become, and of course, the president would have to sign it before it would become law. But I think that one of the things we can see is there's a possibility for some executive action in the form of, executive orders that could achieve some of these things, particularly around the information sharing, possibly. So with that, I'll turn it over to Amber and see if you have any questions or favorite cat.
My cat has any questions?
So I'll turn it over to you, Amber, and I'll feel free to return the favor and watch the chat and Q&A. Thank you.
Yeah, absolutely. Well, so we can hang here for a second, see if any other questions come in. One thing that I'll say before I move on to my piece, and it's relevant to what I'll be talking about. So, I'm talking about ethics and a little bit of lobbying at the state level. And one thing that really strikes me is how much of the rules that you're talking about change from administration to administration. Whereas in California, we have a body of law called the Political Reform Act. It was enacted by voter initiative in 1974 in the Watergate era. And it's been, amended a whole bunch of times, but fundamentally, it hasn't changed other than to, become a little bit more aggressive in the ethics rules. And, certainly if there's, a legislative change, you usually don't see these huge swings. It's more like a scalpel to different provisions of the Political Reform Act. I mean, it's about 180 or so pages long, the Political Reform Act, which governs government ethics, campaign finance, and lobbying. So you could see a flurry of amendments in a session, but they're generally little tweaks here and there, not a whole lot of things that are revolutionary. And it strikes me as you're talking that it almost feels like whiplash going from administration to administration, and this ramp up period for understanding the new rules and really acclimating to it. And I'm just curious how at the federal level that changes, for example, the effectiveness at advocacy at the federal level, and also the enforcement environment.
Yeah, that's a great question. I think that the effectiveness of the advocacy, I think, is interesting to talk about for a second, because what happens really is you will tend to have people that don't want to be the first example, right? They don't want to be, if you've been appointed to your position, you're in the first 100 days, there's a reason that position was filled, and there's a reason that you were used to fill that position. You were given the opportunity to do that. And I think that in some ways it even hamstrings people, or really constrains them in a way that they're almost afraid of their own job in some ways. And in the sense of that is, well, I just got into this position, or I'll give you the example. I just got into this position. I have to be very careful who I talk to, because I don't want to talk to the wrong person. So I'm going to go check with my agency ethics counsel. Well, in that case, it sometimes can take a person to have a meeting that is really, nothing wrong with the meeting. It's really in the purview of the job. But in some cases, you can have political appointees that are a little bit uneasy about having any kind of meeting. And so they might take 2 weeks to get back to you on a meeting request. So to your point about advocacy, If you're trying to meet the target of a piece of legislation or a grant deadline or whatever it may be, that's some other external deadline, that can be impacted by your inability to access people. So I think in some ways the advocacy, and you're right, the advocacy whiplash can be very great. And what we just saw in the Trump administration as well was this sort of top-down approach, from all the way from the White House down to the lowest level government employee. And so you had people that were not sure that they should do anything unless they were told by the hierarchy to do that. You're seeing in the Biden administration sort of a traditional return to agencies running themselves. And so you're right, that's causing the employees a little bit of concern as to what gear we're in, where should I be, exactly what is the role I'm going to be doing now. As far as the financial side goes, it does make it, there's been the long time gift rule about the, less than $20 in the executive branch. And, I think we should all probably be okay with the fact that $20 is not going to buy you a $20 million contract from the Department of Defense. But if you want to grab a hamburger and a soft drink at Five Guys or something with somebody, in some cases now you're not sure, can I do that? I can't remember under the 3 months ago I could do that, and now I can't do that, and so I just can't do anything. So I'll just take the safest position, which is to do nothing. And it just causes some delay. But you're right, there is that whipsaw effect, and it does happen. But we're, it's normal. But we're, everyone here is hopeful that we'll get to some sort of new state of normal. Good question.
Yeah, thank you. And then the other thing that I thought it'd be helpful to flesh out is, so at the federal level, you are potentially dealing with a variety of agencies that can have enforcement authority over your attempts to interface with government. It sounds like the Federal Election Commission is one if you're engaged in political spending or communications. Office of Governmental Ethics, which I'm not sure where that stands right now. The Department of Justice, which may have a whole new department just for FARA. Are there any big ones that I'm missing?
Oh, I think the one big one you're probably missing is the each federal department has its own ethics agency council. And in some cases, there are other sets of laws that will impact that particular agency. So, for example, the one that comes to mind, the easiest, is General Services Administration, which is responsible for procuring real property and also procuring different property and pieces and contracts for the government. And so that particular agency has a whole separate set of ethical requirements and that are legally imposed based on sort of procurement law. So I think those are some big ones that are out there. And I think you also there's one other one, of course, is special counsel. So special counsel's office can sometimes have an impact that they are responsible for Hatch Act enforcement. And what we saw, I think, just from a lawyer's perspective, not political party of any sort, I thought very interesting that you now are able to have the Republican National Convention at the White House. And what does that mean for the Office of Government Ethics moving forward? And I think that's just one of those issues where you're going to say, okay, well, Office of Special Counsel may have a different interpretation of whether or not that is a Hatch Act issue, and whether or not the people that attended that are also government employees, did they attend in their official capacity, and was that actually a Hatch Act violation? So Hatch Act looms in the background in there, and it's also particularly important for a lot of the national defense folks that are in the area, because the Hatch Act has certain applications for defense, national security interests, so DoD, Homeland Security, and FBI and Department of Justice and the like. So it's kind of interesting.
That is, I'll talk, we can turn and talk a little bit about California now, but I wanted to flesh that out a little bit because, California, so as you know, our practice, we do 50 state government ethics and campaign finance and lobbying compliance. And I think universally, California is regarded as, one of the trickiest thickets to navigate in terms of compliance. And, part of that is just we have a lot of regulation. and some of the more complicated rules. But I think unlike what you just described, we have one main agency that regulates each of those laws for the most part in California, and that is the Fair Political Practices Commission. And some people might think of it as the California equivalent of the FEC. And that's sort of fair, but the FPPC also regulates lobbying, also regulates government ethics and gift rules and conflicts of interest. And it reaches not only state level officials, but also down to the local level. And so, in one regard, we have a little bit more consistency in California in terms of the body that is promulgating the regulations that interpret the statute and then enforcing it. And then another distinction, I think you mentioned it when you were talking about HR1. HR1 would change the composition of the Federal Election Commission. One of the reasons that HR1 is looking to, one of the goals HR1 is trying to achieve with that is to break the gridlock that happens, because right now the FEC is evenly split, 3 Republicans, 3 Democrats, and so they have perpetual gridlock, and that holds up everything, including even approving little settlements over minor offenses, minor violations of the Federal Election Campaign Act can be held up for months. In California, we don't have the gridlock problem, and so there's pretty robust regulatory agenda and enforcement that happens on a regular schedule. So I think the regulated community in California actually benefits from that level of consistency, and it's not happening with the change of administration or by executive order. And I know that certainly as a lawyer, I appreciate having a reliable body of law that I can point to when I'm advising my clients about how to navigate these things.
Sure. I did have a question for you that you made me think of, and that is if you could talk a little bit about how you think the new composition, if HR1 was enacted, what do you think the new composition of the FEC to an odd number would really mean for the regulated community? And also, what do you think it would really mean for business entities that sort of dabble into political activity, but may not even realize that they've gotten there? And I don't know if you could talk about that a little bit.
Well, I mean, that's a really good question, and I think it could have a really big impact. The reason why, and this actually helps demonstrate another really big difference between the FEC and here in California, the Fair Political Practices Commission. Pretty much everything that the FEC does has to be approved by the commission, including even opening an investigation. And whereas in California, the agency can do almost everything at the staff level, and the FPPC will vote, to approve or reject different settlements, but everything is driven at the staff level. And so I think when you have a lack of quorum, which the FEC has had because it has that 3-3 composition, then lack of quorum or lack of agreement, then nothing gets done. The agent there was a long time when the FEC didn't even have the ability to appoint an in-house general counsel for themselves, didn't even reach that kind of an agreement. So I think it certainly from a good governance perspective and democracy perspective, you want to have a functioning body that will be good. If you are dipping your toes in the water, then I mean it certainly I think it changes the risk analysis of what you're doing. I mean, some things are cut and dry, and you know what the rules are and you follow them. Other things are a little bit less clear. So, knowing where the agency stands on something or what their enforcement priorities are, help with the business calculation of when you're deciding on, how and whether to engage in a particular type of advocacy.
Okay. Well, thank you for explaining that. Appreciate that.
Yeah.
I didn't know if you were gonna, I'll turn it back over to you.
Oh, yeah. I mean, so I thought I would go through, compliment a little bit more on the California side. Some of the things that you were talking about. One thing, well, you're talking about the revolving door issue, and that is something that California has a parallel set of laws. But not in the way that you're talking about. So not where if somebody is a lobbyist, can they go into government? I don't think there's any issues with that. The way our revolving door rules are set up, if you are working on the government side, there's a number of restrictions on switching and going over into the private sector. And those rules are really broken out into whether or not you are in your public role, if you're an elected state legislator, if you are a staff person, or if you're a local level employee, so maybe a general manager of a city, for example. But it also covers any state agency, so Caltrans, Department of Managed Healthcare. This is an area where we've seen, that saying, no good deed goes unpunished. And right, you
Yeah.
have going along in their life and not even realizing that they're covered by these laws. They think, oh, I'm just a low-level agency employee, and they start negotiating with a future employer, but who happens to be on the private side. Suddenly you're covered by these rules and you might be violating them, and the fines can certainly be substantial. But again, I think, the distinction between federal and California is, these laws have been on the books for decades, and we have also decades of advisory letters that have been written by the FPPC. So if you are on the regulated side, you can have a really good roadmap of what you can do, or more importantly what you cannot do. We have a cooling off period, for example, if you're coming out of CalSTRS or CalPERS, a retirement fund. There are certain periods with which you can't turn around and go back to a retirement system and do certain types of lobbying. But again, all of this isn't at the whim of the governor. This is in laws that were passed by voters.
Right. So I guess that's a question too, or really, you raised a good point about the, something that I didn't necessarily mention, but you raised a good point of is this really trying to get at this, I was thinking about the Obama administration and how you really couldn't be hired if you were currently a lobbyist. So what we saw a huge, it was almost this orchestrated dance of they would take the first sort of wave of folks off the Hill, and then that would create a sort of backlog of Hill spaces on Capitol Hill, staff slots available. You'd see these lobbyists making, anywhere from $200,000 to $300,000 or something like that. Huge six-figure salaries become staff for some member of Congress for exactly 5 to 6 months while they're waiting for their appointment to be cleared by the Office of Presidential Personnel. And then they would go into some agency that they probably had a lot of knowledge of because they had worked on some of those matters, or that was in their space. And because they had it was like sort of the touch and go, I think is how we were sort of calling it, but that people were sort of touching down on the Hill briefly, and then they were going into the administration because they were now no longer lobbyists and they were in fact government employees. So their ergo, they were able to fill these roles. I think part of what we saw in the Biden pledge is to try to eliminate that by having a look back window. And I think the other part of that is a look forward window on the whole golden parachutes about government employees sort of being able to cash out and go to contractors in particular. And I don't know if you have the same kind of prohibition in California? And if you do, maybe you could tell us a little bit about that.
No, we don't have that kind of prohibition. What we have is it's called the ban on influencing prospective employment. So what you are doing is, while you are still employed, from the moment essentially that you get invited to come in for an interview, or you submit a resume, once you're under consideration with a private side employer, you are no longer allowed to use you can't make governmental decisions that would benefit your prospective future employer, which makes sense, right? You certainly to abuse the public's trust in your position to benefit a private employer with the hope that you will actually get that job.
Got it. Well, and I'm going to throw a complete curveball at you here. We didn't, for everyone in the Zoom world, we did not rehearse this question at all, but do you have any thoughts on, or have you experienced what's happened with a government attorney in California going to a private employer, or vice versa? And if you've ever had to advise any of them on how to comply with that?
Well, so that actually would be covered by a different set of revolving door rules that are covered. So, one of the revolving door rules, I think the easiest to conceptualize is, if you are a legislator, you've got to take a year off and cool off before you can come back and lobby the legislature. The other one I talked about, there's this ban on influencing prospective employment. There's another one, these revolving door rules. One of them is called, it's actually a permanent ban. There's no off period, and it would apply most directly to a lawyer is a perfect example. But anytime you're working on behalf of your government agency employer on a matter that has a judicial resolution, you can't switch sides. I mean, it's very similar to the type of rules that we're governed by. I certainly couldn't go over to opposing counsel's side and say, hey, I'm going to work on you now and bring all of my knowledge with you. So I mean, that is not unique to lawyers. It would be anybody. Yeah, like another example, if you're working for the Franchise Tax Board and you're working on an audit, you wouldn't be able to go work for the entity being audited in the middle of that audit, right?
Right.
So that's probably the one. Again, it's not unique to lawyers, but lawyers might uniquely find themselves in that situation. So that would be potentially implicating not only like the professional ethics we're governed by, but also the Political Reform Act. So if you get in trouble with that, it could be a double whammy penalty.
Okay. So let me ask you this then. What are some of the nuances that you see coming in enforcement at the state level that could be impacted by what's happening at the federal level? Like, I don't know if there are some examples that you are thinking about or working on that you could kind of talk about.
Yeah, I mean, I think one thing, and this is going to sound a little tangential, but it is related. We've heard, hopefully most people by now have heard that phrase dark money, especially for Citizens United world. That part of what HR1 is contemplating going after is, spenders who are hiding their money behind nonprofits, right? These social welfare organizations. In California, we've got that covered. If you spend $2,000 or more in California, you could potentially be disclosing your donors. We have extremely comprehensive disclosure for nonprofit type entities. The new focus has moved to limited liability companies, and so the concern is that an LLC is, just a legal entity that you can buy the name off the shelf, and a lawyer can register it, and so an LLC can donate in California elections, can donate unlimited amounts of money to, ballot measures and recall campaigns, just like anybody else, but you don't know who's behind the LLC. There's not much information provided in the filings on the Secretary of State website. And so last year, the FPPC adopted a regulation, which is now in effect, which requires the campaign recipient. So, if I'm a candidate, I receive a contribution from, Acme LLC, my treasurer would have to reach out and say, who is the individual who directed that contribution for the LLC, because that person's name now has to go on my campaign finance disclosure report. It's no longer just the LLC. And there are now two pieces of legislation moving through the California legislature. They were just introduced at the beginning of the year. One would treat an LLC like a political committee. So require it to register and report who its donors are. Not quite sure how they would define that. Another piece of legislation would require LLCs that make contributions in California elections to submit a list of its members who provide capital contributions to the LLC in a certain amount. So, there's a real drive and a real motivation right now by both the FPPC and the legislature to peel behind LLCs. And I think one of the reasons why is, peeling behind the nonprofits to find out who is funding those. California we did that already. I think the federal level is still very much grappling with that. That's a big goal of HR 1. I'm not taking a policy position on any of this. But so California now is moving on to LLCs, and I think what we might see is the federal level catching up to California at some point down the road in that regard.
Okay. Well, I didn't know if you had any. I did not see any other questions come in. I don't know if you were quite finished with your presentation there.
For any other questions?
The only other question that we had were just some, if there are any examples of challenging policy issues that you see forthcoming, but maybe, I guess there was one that came in, it's kind of related, but it was about real estate entities that are using foreign investment and commingling domestic investment, and sort of, are there issues for those kinds of LLCs or companies in California that you're aware of?
I mean, I think that is one of the concerns too, being addressed by the LLC disclosure that's coming up. Certainly here in Los Angeles, there's lots of development. Downtown LA was going through a development boom before COVID, and there's a lot of foreign investment coming into the Los Angeles area, and we are literally still in the throes of a massive FBI investigation. The investigation is ongoing, but we now have 2 former city council members, one indicted, one who has been sentenced already, and a lot of the allegations around that were around bribery and taking money in exchange for taking favorable council action or official action to help move these development projects forward. And so I think, but I mean, that case opens so many different parts of what these rules are meant to prevent, including the influence of foreign money, the lack of disclosure of money being used to influence elections. But then, of course, this is a crime at the federal level and in every jurisdiction, which is quid pro quo taking benefits in exchange for official action. So I think we have a ways to go with that investigation here in LA, and we'll continue to see, the LA Ethics Commission and the FPPC, come up with new regulations to try to stop it accordingly.
Right. Okay. Well, I think that's also, I mean, if I was to take the federal spin on the same thing, I think that obviously that's what HR 1 is attempting to get at, as you pointed out, but it could really pose a challenge to entities that sort of dabble in this world and may not realize that, the occasional check to a federal candidate that now has to show up on a federal disclosure. And what does that mean? And did you also by chance issue a check to a state candidate, or where have you now run afoul of both your state and federal disclosure requirements or the like? So I think those can be very tricky with respect to companies that tend to blend foreign money, if you will, foreign investment with domestic investment. So that can be something that's kind of tricky and something worth watching. So I think that's good. I don't know if we have anything else. I didn't see any questions come in. I'll take one last look, and I don't know if Alex is still there. I know that we have a few minutes left. If there's anybody else that has a question of any sort, feel free to put it in either the chat or the Q&A.
I'm here and I cannot see any questions. So if you have any closing remarks, anything else that you would like to add to the program?
Just to say thank you for everybody, I think, and we appreciate your time. Feel free to look us both up. We are at Nossaman, and Amber is. I don't know if you have anything you want to mention, Amber.
No, just thank you very much for having us. It was a pleasure.